Welcome to the latest Evershed Sutherland Legal Insights podcast.
Very excited to welcome here today three experts on in our sort of data as an asset series, but specifically in the context of data in the public sector and dealings with public sector bodies. Liz Fitzsimons, who's a partner in our global privacy and cybersecurity team, and has a specific specialism on freedom of information and environmental information regulations, based in our Cambridge office. Liz Marshall, a procurement specialist, and also Nicolette Sanders, who's a legal director in our governance and infrastructure team, and has a specific specialism in government-facing strategic policy, which is, well, it couldn't be any more topical given the amount of elections we're having, and also the UK election last week. So this is really right on the money, this session. So our podcast in this series are focused on data as an asset in various contexts under new legislation or in certain sectors. But in this podcast, we wanted to look at any additional or different issues facing public authorities or those engaging them in relation to data. And the key thing there is the common misconception is that in relation to, for example, food information, sometimes clients and others can think that this is only relevant to public authorities, but actually if you're a private sector body or company and you deal with a public authority, you equally need to be fully aware and on top of this stuff. For example, if you're responding to a tender and a bid or sharing any confidential or sensitive information with a public authority, because that information may fall within a FOIA request. When I say FOIA, I mean the Freedom of Information Act request. So it's as relevant in the private sector as it is in the public sector. So with hopefully that's a good starting point. But Liz, I mean, you have a fantastic amount of experience working for and with public bodies and helping clients work with them. So could you explain some of the extra or different rules that apply to data in the hands of public bodies and what sort of key issues arise?
Thanks, Phil. It's a really good question because there are additional legal regimes that apply once it goes over the fence and it's in the hands of these public bodies, because any record of information they hold, doesn't matter who it belongs to in terms of ownership or IP rights or anything like that, if they hold a record physically or digitally of information, then anybody in the world for any good reason, which is just I want it, can ask for it, and then the public authority has to deal with that. And there are various rules that apply under different regimes. It's quite a complex space because there are different layers of legislation. They affect different public bodies for different information and with different get-outs. So I'll just give you a flavour of it today. So the main act is our freedom of information legislation. That's been around in the UK for about 20 years. That's just pure domestic created legislation. And that affects any information records that these relevant public authorities have. And with this statutory right to know that got created, anybody can ask for a record of information. Do you have it or not? If you've got it, the default is you have to hand it over. And it doesn't matter why they want it, whether it's because they're your competitor, because somebody's trying to find out about a likely decision, they think something's been going wrong, they just want to understand things more. And then the public authority has a very strict timetable for dealing with that, a very limited ability to say no, and has to explain why. There's also a form of that applies only to environmental information. It applies to some, but not all of the same public bodies, but it also affects different public bodies on top. And there are different rules for being able to say no, but the basic premise is you can ask for it. If you've got it, you hand it over, unless there's a jolly good reason that you can justify. And then finally, the icing on the cake is that different public bodies, again, and it can overlap, can be subject to reuse regulations where public sector information can be requested to be reused. So in that case, people can get licenses to make any sort of commercial or other use of these information records, again, subject to different exceptions. So there's quite a lot to think about there, really. And as people have become more reliant on technology, data and records have absolutely exploded. in volume and complexity, it's got more difficult for the public authorities to keep ahead on this, to deal with it in a very timely way. And people are often unhappy, unfortunately, with how they've been treated on their requests, whether or not that's justified, but have rights to complain. It can go then to the regulator, it can be appealed to a tribunal, and in effect, a public body can be ordered to hand over the information if the regulators and tribunal don't agree with how it's been dealt with.
Thanks, Liz. And I've got another question I was going to ask you, but just coming out of what you've just spoken about, I mean, some of these, like for example, handling a FOIA request, it's not that straightforward sometimes, is it? It's pretty technical, which I know you and your team love because you like a challenge, but it's not straightforward.
No, there's an awful lot to think about in that. On freedom of information itself, it very much varies on the type of authority you are, your type of sector, operations, the type of information you hold. And then you get up 23 odd flavours of exemptions, plus other grounds to be considered for giving things out. Sometimes you have extra hurdles like public interest tests that have to apply. So there's a lot going on. And
as you discussed that to a certain extent, the laws in the UK, but what about internationally and globally? Are there sort of similar laws in the EU and elsewhere?
Yeah, interestingly, that's also an expanding area where the freedom of information area is a bit more ad hoc. So you see that in various countries, say around Europe, but increasingly you see a lot of that through the Caribbean, through the African countries, and so on. The environmental information flavour of the legislation is EU-wide. That all got driven out of an EU directive and international treaties that grew out in Europe. So everybody has a flavour of that in their local legislation to comply with that directive around Europe. But we also have other countries around the world that are taking this on board because people see the benefits in transparency and accountability, and especially on environmental matters, and bearing in mind all the ESG requirements these days and the good reasons that people are so keen on working in that space and doing more. Even the European institutions have their own flavours of this sort of legislation. And Europe, of course, went one step further in that in September last year, the EU went live with its Data Governance Act, which is really a regulation applying across the EU countries. And this is part of their data strategy as a whole, really ambitious. And it creates this very new framework to try and unlock the value of data in the hands of public bodies. And then, in effect, through a series of brokerships, make it available for use across that region, across borders, by other businesses, entry-level businesses, to really help drive data-driven economies and growth and benefits through the region. And it's really interesting how different areas have really embraced this sorts of transparency. We even see this now across the Middle East. Even in China, there are certain open government legislation developments that have happened. And quite often it reaches out into the private sector as well, where they also have this. So, for example, in South Africa, we've recently been advising clients because they have to provide public access to mandated types of information and sometimes have to do annual reporting on this to the authorities there. So it's a real growth area and something that clients really should have on their radar.
Thank you very much. And this brings us neatly on to other organizations. So how do these laws impact businesses that interact with these public authorities? So, for example, private sector and other organizations.
Well, I think really it's a question of awareness, because the minute your information is sent over that dividing line to a public authority, in effect, it is at risk from this legislation because the authorities would have to deal with any requests that come in and make their decision on how to deal with that request, what to hand out, what to hold back, if anything, and why. And they have the sole discretion on that. Unfortunately, under most of the legislation, affected private bodies and organisations whose information is affected by these requests, but in the hands of public authorities, don't have any rights at all under the actual legislation. They don't need to be told about a request coming in about their information, kept up to date. Ideally, best practice, they would be consulted and be able to give views, but the authority doesn't have to agree and can then make its own decisions. There's no right to block that in the law. There's no right to appeal to the regulator. There's no right to appeal that. There's no right to get compensation. So it's a challenging space for private bodies interacting with public authorities. And you should be very aware of these issues, safeguard your information, and really take steps to pre-think what is provided and subject to what controls and protections, and be able to defend your position very ably. If you get a request from an authority that says, I've had a request for your information, you've got 5 days to tell me whether or not you've got a problem with this and justify it. And quite often 5 days is a luxury. So yeah, it's an interesting space for people working in this sort of cross-sector area.
Thank you very much. We'll probably come on to this a little bit later, but especially with you, Nicolette. But I know obviously Labour, having got in the UK with their manifesto, that they've part of their strategy is to leverage AI, of course. And of course, what data they're going to put in that, whether it's theirs or someone else's.
The fascinating discussion, yes.
Yeah, and also the concept of a national data library that they're going to build. And obviously, like with any manifesto and stuff, some of the details are a little bit light. But essentially, a sort of centralized data pool or data lake of stuff that's going to sort of innovate and enable sharing across public sector bodies and everything else, which is a great thing. But of course, it's not without issues from a legal perspective.
No, and we can come on to discuss that in a minute, but it's, I think, fraught with complexity, from a legal perspective and also from a delivery perspective, if you're talking about government and big IT projects as well. But we can come on to that in a minute.
Yeah, and even the likes of some of the large tech companies and having sort of single customer views and stuff, it's not straightforward. So Liz F, if I may call you, because we have another Liz, Liz Marshall, Liz M. If I may come on to you, because I'm very jealous of your specialism in procurement, because I wish I knew more about it, and you're always a fantastic source of guidance on the topic. But are there any specific aspects of public transparency and access legislation that clients should consider in the procurement context?
Yes, thanks, Phil. Yes, I think actually this is a really good time to talk about this and the alignment between what Liz has been saying and this particular area, because it's a really exciting time for procurement lawyers and practitioners, because we have new procurement legislation coming into force for England, Wales and Northern Ireland. It's very relevant in the space we're talking about, and it will have a major kind of impact on transparency for affected bidders and suppliers, and obligations for buyers in particular. So the Act itself was made in October last year. It comes into force on the 28th of October this year, and it consolidates all of the separate procurement regimes we currently have, which are derived from the EU directives over a number of years ago, and such as those applicable to particular buyers in the public sector, those buyers in the utility sector. All of those are currently in separate regimes. They're all being moved into one place, and it creates new rules for us in this country, and is a key post-Brexit reform. Although I always think it seems interesting that it's taken well over 4 years to get to this particular point, and for new legislation to be in place.
Very interesting. Well, just looking at that date, 28th of October 2024, that's not that long away, and it's also not far from Halloween. But maybe they chose not to choose that date. But I don't know, is it whether you view it as a Halloween act, or actually it's an improvement?
I think there are real positives and real negatives, as there often is with new legislation. There's a lot more flexibility that buyers have been given with the rules in terms of processes. Obviously, with flexibility often comes procurement law risk in how those are operated and how those are designed. But there are still some core and key parameters within which those tender events will be accessed and run. But basically to say that on the whole, there are some positives for the new regime for buyers and suppliers, but also some more onerous provisions and more concerns that are being raised, particularly the transparency area.
Thank you. And how is information and data about a procurement or flowing from a contract dealt with by the new Act?
Yes, so this is kind of one of the key themes throughout the new regime. It basically permeates the full life cycle of a contract. So there are transparency obligations both before a procurement starts and during the procurement, but also during the life of the contract, all the way up to the re-procurement of a contract or the termination of it. So it's fair to say some of this builds on what we've got existing and align with the freedom of information legislation, and for certain public bodies and sector, we obviously already have some proactive publication of limited procurement and contract information, and that's been happening for some time, but this really builds on and expands on that. So a buyer governed by the new Act is going to have to plan for lots more transparency, and there are a raft of notices that they will need to publish. So I thought it was worth just going through these, a very quick run through. It's a fairly long list, but it just gives you a flavour of some of the new notice requirements and obviously the greater transparency that both the buyers will need to give and the suppliers will have access to. So if I just kick off with these, there's obligations to publish notices about a future pipeline of contracts. There's an obligation to publish a market engagement notice, although actually this is voluntary. A buyer will actually need to explain why it's not published a notice. So even though, as I say, that's voluntary, there is a kind of sense that you'll have to explain why you didn't do something rather than just do it. There's the need to publish a tender notice when you want to start running a procurement, so that's pretty much similar to what we have now. There's a contract award notice, again, something that is known within the current legislation, but in the new Act, that's got to be published before a buyer enters into a contract at the end of a tender process rather than after it. So there'll be more transparency there. A contract details notice now takes the place of a contract award notice. That's published after a contract has been entered into, and also for public contracts above £5 million, redacted contract and KPI information about that contract will need to be published, and I'll come on to a little bit more about that later on. There's also a transparency notice before a buyer enters into a contract where a competitive tender process has not been undertaken. So that would cover direct award of contracts and is kind of an interesting and new area where additional transparency is going to be given therefore before rather than afterwards. There's a contract payment notice detailing payments over £30,000 made under contracts that will be published quarterly. I'm still going. There's a contract performance notice published annually to report on KPI scores for public contracts worth over £5 million. But also buyers will have to report on poor performance and breach of contract within 30 days of the event. There's a contract change notice that has to be published before a qualifying modification takes place, and for contracts that are worth over 5 million, you'll have to publish a redacted version of the modified contract. A contract termination notice, clues in the title, a procurement termination notice, clues in the title, and a payment compliant notice detailing where a buyer's performance against a 30-day payment terms that's published twice a year. So there are exceptions to publication of some of these notices, so certain private utilities and for certain types of services such as light touch services. But most of these are mandatory, and they will require public bodies to publish much more information at more points throughout the life of a procurement and the awarded contract. And also there's also already been legislation secondary legislation and regulations published setting out all the information that needs to go in these notices.
It's a real enhancement, isn't it, Liz, of what some, but not all, public authorities have had to publish so far, where a lot of that has been more voluntary, but definitely more limited. There's an awful lot more granularity here that we're going to see kicking in. And it's going to be interesting to see if contract terms mandate that suppliers and contractors have to actually provide this performance data and how granular that gets. And that brings its own interesting challenges under the legislation as well.
Yeah, absolutely. And I think what's important, will be important for suppliers, is being concerned about what that information is that the buyer will need to have access to, and actually whether performance or contract data is accurate at the time when it needs to be published. But I agree, I think this does build on a lot of what is already in the existing regime, but it also alters the time frame for this and just moves the dial backwards a little bit, so that activities that were reported on afterwards are actually being reported on before. So that has a positive, because it gives the buyer certainty that it can proceed with what it wants to do outside of challenge periods. But also it does mean that if there are issues around it, suppliers can access more information and more opportunity to complain.
That was a very long list. I'm still recovering from it, Liz. But it's a little bit like sort of publication schemes, isn't it? Making, I suppose, one way, there's an initial session about freedom of information. One way to sort of address that proactively is to have publication schemes where you make some of the data available proactively to address some of these requests. And the danger with any of these obligations to make data available is you end up making more data available than you perhaps should do. And they breach confidentiality, or maybe it's got some personal data in there, or breach a license term, or all sorts of other things. That sounds quite a lot of fun, Liz. So what about from a supplier perspective?
Yeah, so I think what we're seeing is, in addition to some buyer concerns about the onerous level of notice publications, the contents, the timing, etc., is that these new obligations on buyers and the increased disclosure of data is raising concerns with quite a lot of our supplier clients. So if you think of it from the perspective of a winning contractor, so data about their performance or issues with it clearly might be disclosed to the market. And we think there's going to be much more upfront focus on what contract KPIs are during a procurement process itself, and whether suppliers are happy that they are correct KPIs, that they're happy to have their performance judged against them. And also more disputes around whether KPIs have been triggered, or if performance is considered to be poor, or if a public body seeks to terminate a contract. We expect there to be much more kind of disputes around that within the life of a contract as well. So I think overall, from a supplier perspective, we expect the new regime and how onerous it is to be a particular area of focus for suppliers. It also might have wider consequences than just the contract awarded as well. So what we currently have in the regime is a discretionary exclusion ground for certain quite limited circumstances around poor performance of a contract or termination of a contract. And the new regime actually expands on that, and basically, for example, gives a public body, any public body, a discretionary right to exclude if a contract has triggered a, say, improvement plan and then not improved the contract, so it gave rise to a termination right. So we think, a bit like Liz was talking about earlier, suppliers are going to kind of pre-think and pre-plan kind of what they're prepared to live with through the life of a contract, and therefore particular focus, as I say, on KPIs, contract performance data, what's available. I think for suppliers other than the winning contractor, there's obviously going to be a lot more opportunity to get data about a particular competition, and also a lot more data about each active contractor during the life of a contract. So anyone looking out to see how people are getting on, whether contracts are coming up for renewal, what performance has been seen by their competitors is going to be available in the market. I think finally, just to say, and similar to what Liz was talking about earlier, is there are exceptions to publishing data within the new regime, and it's similar to what we're used to. So, for example, a buyer is not required to publish or disclose information if it's necessary to withhold it for the purposes of safeguarding national security, for example, or if there's commercially sensitive information and there's an overriding public interest in that being withheld. So again, that raises this public interest test. And we think that means there'll be a lot more internal discussions around the application of the public interest test. There's likely to be more pushback from particular contractors wanting that information to be withheld on that basis. And they may even try to put contractual provisions in contracts to tie the hands of the public body over what they think is considered to be particularly sensitive. And also more pushing by other suppliers in the market to get that information disclosed and alleged, arguing that there's public interest in disclosing it. So we think that that'll bring in more alignment with Freedom of Information Act requests, and interesting times.
It's dangerously different though, isn't it, Liz? So it's going to be, you might be able to block it on one hand under that regime, but actually you still got to consider it differently in the available grounds under the other regime. So it's going to be interesting to see how it plays out in practice,
Absolutely.
Especially initially, I think.
With that, I think often where you have these overlapping regimes in relation to similar but not identical areas, it can require a lot of stepping through to begin with. And I can see this is something where clients might well need a bit of help to kind of get through the complexities. And the government itself will, of course, not necessarily have worked through every aspect of how this might work.
Absolutely. And I think it's also, we do frequently see if suppliers request information from public bodies, that they tend to push for a request under the procurement regime as it currently is, but also in the alternative and in addition an FOI request, because they know that then it has to be dealt with separately under each regime. But it's quite difficult to argue, for example, disclosing it under one and not disclosing it under the other. So I think it'd be interesting to see how it all pans out.
I know it's outside the scope of this session as well, but we have had previous talks on the EU Data Act as well, which is separate to the Data Governance Act. And you could have a situation where suppliers having to make all this data available, also maybe considering FOIA stuff as well, but then also maybe being asked for information under the EU Data Act as well, where it applies from an extraterritorial perspective, which adds another layer. But that's sort of going slightly outside of our focus for the moment. But so Nicolette, saving the best till last. You've worked in central government and have deep specialist knowledge about how the way it works. With so much legislation to drive and improve transparency, openness, and improved public scrutiny, just wondering whether there are any other ongoing or new challenges, especially from the sort of relentless advance of new technologies such as AI and ability to misuse data and spread disinformation, whilst also, of course, recognizing the great benefits and opportunities it brings to innovate. I was going to, so how are national authorities responding to these risks, and especially given the context of the elections, it's super topical.
Yeah, thanks, Phil. There is so much to talk about here. I mean, this is an absolutely fascinating area. And for me, this is going to be one of the big game changers for government over the next few years. I thought I might talk a little bit first about the election and the kind of impact of AI there, and then we can move on to talk about what we might see in the future, because this is going to be a huge focus for government. There was obviously a lot of chat in the run-up to the election, the UK election, about the potential for AI to disrupt or to even manipulate the outcome of the election. I think it's fair to say from where we are, which is obviously we're recording this a few days, well, actually a week after the election now, I think it's probably fair to say that it's been the dog that did not bark in this particular election, and that there wasn't necessarily a big impact. This is looking back on previous elections. For example, the Intelligence and Security Committee in 2020, which is a parliamentary committee, assessed that there were serious attempts by Russia to interfere in the UK elections, particularly the 2019 election. So I think there is no reason to be complacent that this won't happen in the future. And obviously we have the US election coming up, where the stakes might be higher. So I think it is instructive to think about, yes, maybe we got away with it this time round, but looking forwards, government doesn't necessarily have the option not to regulate and think about the challenges of AI and disinformation for future elections.
And what has been the response to date? And does government have the tools to manage? How effective are these tools domestically, at home and abroad internationally?
I think it's fair to say that the response has been a bit of a hodgepodge and really not particularly well thought out or indeed tackled at a strategic level. We saw in the kind of recent election that regulators like the Electoral Commission, who looks after the electoral process, were putting out guidance which didn't seem to me to really scratch the surface. It was like, if you see disinformation, can you report it to your returning officer at an election, which probably isn't going to be the magic bullet there for solving this particular issue. And there are some other pieces of legislation out there, the National Security Act 2023, which makes an offence of foreign interference in elections. And I think what's interesting, looking at the manifesto that the Labour Party put out, so for the new government, is they placed misinformation very clearly in the context of national security. And looking forward to their strategic defence review, they're also planning a new regulatory innovation office, which where they comment, perhaps presciently, regulators are ill-equipped to deal with the dramatic development of new technologies, and a new regulatory innovation office is seen to be the solution. So I think there is a recognition that this is a challenge. Whether they have the tool, I don't think they have the tools at the moment to deal with this, and to what extent a new Quango, a new NDPB is going to be the answer, and whether it will provide the answers quickly enough is going to be a big challenge, I think, over the next few years.
And also how they interact with the existing regulators, because they all have different data responsibilities, but they're all going to have to work very closely together to have the correct sort of joined up impact.
Yeah, and I think in terms of joining up, I know that, again, the new government has just announced that the Department for Science, Innovation and Technology is going to be taking in the various different offices across government. So, for example, the Government Digital Service, which was responsible for Verify and other kind of initiatives to bring together single data access points, if you like. They'll all be centralising it into one department now. I think with that very aim of a sort of joined up approach. In a way, I feel like this is a missed opportunity, because actually each department, each bit of government has to own the opportunity in this area. But actually, I think at the moment the government is seeing it as, if you bring it all into one place, it can really drive forward that digital transformation that they need, and they will be more joined up and they won't be kind of dropping of the balls. But it's also interesting in that they still view it as something that is done by a specific department rather than something that each and every department has to really mainline into their agenda.
And on the sort of international stage, I know we've been discussing some of the UK implications, but are there similar issues you'd say arising there?
I think so. I mean, again, looking at the US, they have got some regulation at state level, but they've got no federal approach. And I think it's fair to say that, as with all, I think we're talking here about sort of the regulation of AI and disinformation in relation to elections. It's kind of got caught up in party political disputes, as seems often to be the case in the US at the moment, and it's highly unlikely there's going to be anything in place before the election actually takes place. And in fact, the onus then falls back on the tech companies and social media companies to take the initiatives themselves. And this is what is happening very much at the EU level, where there has been there was a big security conference earlier in the year where the tech companies were signing up to commitments to deploy technology countering harmful AI-generated content, which is intended to deceive voters. So I think it's fair to say that at the moment we have the same problems which have perhaps beset government over the past year or so, is that technology itself is far outpacing the what government can do and the pace of the regulators. And you mentioned earlier on the kind of national data library and the kind of ideas that government itself is trying to bring forward. But in fact, whether it is regulating disinformation or elections, or actually trying to harness the power of AI for public services, government itself is still very much in the foothills here and needs to catch up. And as well, the regulations and the legislation around this needs to catch up as well if we're all to be feel confident, the public to be confident using this, and companies to feel confident as well in working and delivering for government.
Thank you very much, Nicolette. I mean, I think we've covered an enormous spectrum of topics there. I'm also conscious of time, but just before we sort of wrap up, I don't know whether you or either of the Liz's had any sort of parting comments you want to share with those who are listening.
So from my perspective, I would say, the government perspective, I would say, watch this space. I mean, Tony Blair and his Institute for Government have said that this is the key area for government to be thinking about if it wants to deliver the growth and the better public services. So this is going to be an area of huge innovation in government going forwards.
And I think everybody's got a stake in this, because the sanctity of data, its value, its integrity, has such a resounding influence and importance to everybody, no matter what sector, whether you're public, you're private, whether you're an individual. We all rely on it now, and so this really does matter.
And on the procurement side, I think that there is certainly an awareness that AI and how it might be used both by buyers and suppliers is an increasing kind of tool. On the buyer's side, there's an obligation for central government, but also an expectation for all public bodies that they will seek to understand whether AI is being used in the generation of tenders. And there's obviously an expectation and a requirement and a duty really to verify the information, that's to check that information, see whether it has been auto-generated and assess whether it's accurate and valid. And then from a supplier's perspective, obviously, if they do use tools to generate tender responses, then they're going to need to show how that's been done and the tools that they've been used. So I think that it's permeating its way throughout all areas of the kind of public sector, whether you're involved in on the buyer's side or whether you're involved in delivering.
Thank you very much. And I think one thing's clear, that the common thread with all of this and the use of data goes back to trust, and public authorities being in a very great position of responsibility in holding all this information, whether it's in relation to individuals, consumers, or private sector, and being trustees and guardians of that. And if it's not handled well, if trust is damaged in those public sector organisations, it can be very difficult to rebuild that. So there's a great opportunity, but it also needs to be handled carefully. But I just sort of draw things to a close there, and I'm very, very, very grateful for the contributors' time in participating and preparing for this. To you, Liz, Fitzsimons, and Liz, Marshall, and Nicolette Sanders, thank you very much.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.